Hello and welcome to this edition of the Bellevue Brief, the podcast from the team at Bellevue Law. I'm Susanne Hartigan, Head of Legal Practice, and I'm joined by my colleague Anjali Malik as one of our associates at Bellevue. This episode forms part of our short series looking at the reforms of the Employment Rights Act 2025, and also to talk about practically what they mean for businesses and HR teams. Today, we're going to look at some of the trade union reforms in the Act. And the government's stated intention behind these various reforms is to strengthen workers' rights in the workplace and to empower them in the workplace. There has also been a drive to repeal what has been seen as the anti-union legislation put in place by the last Conservative government. And some of that legislation was repealed on the day of royal assent in December. There is a huge amount of trade union reform in the Act. So today we're just going to touch on a handful of areas which we think will matter most for non-unionised, small to medium-sized employers who might not have had much to do with trade unions so far. If you're currently not a unionised workplace, the Act is going to bring in several changes that will make it easier for unions to gain access. I think it's just worth flagging we're recording this podcast at the end of February, just in case anything changes before we record this and when the episode goes out. So, Anjali, let's get started into this quite difficult topic if you've not had experience of trade union law before. So can you talk us or start taking us through some of the key reforms to do with trade unions in the Employment Rights Act?
Yes, of course, Suzanne. So to kick us off, let's talk a bit about the new right to join a trade union. So at the moment, employers aren't required to proactively inform workers of their right to join a trade union. But the government believes that this lack of awareness contributes to the declining union membership and any reduced engagement with any collective bargaining. So for those of you who are new to trade union legislation, collective bargaining is where a trade union negotiates with an employer on behalf of a group of workers about pay, hours, and any other employment terms. So a big change to be aware of under the Act will be a new requirement for employers to provide workers with a statement confirming their right to join a trade union. And this is likely to come into force in October 2026, so later on this year. So the details of the new statement have not been finalised yet, but we do know the government's preferred approach in some areas from consultation on this reform, which closed in December 2025 of last yeyear. So, Suzanne, do you want to take us through the details and format of this statement?
Sure, I'll do the content and form and you do delivery and frequency. So as you mentioned, it's all set out in the consultation. So let's look at the preferred approach to content. So this statement is likely to cover off four areas. The first being a brief overview of what trade unions do. Secondly, a summary of workers' statutory rights in relation to trade union membership. A list of any trade unions which are recognised by the employer. And finally, a link to a government website which will list approved trade unions. So bear in mind, this is a statement that's going to be given to existing workers and new joiners. So really, it's really good advertising for trade unions. And then in terms of form, the government's preference, as stated in this consultation, is for a standardised government-issued template that employers will complete with workplace-specific information. So, for example, if they currently recognise a trade union, that will be stated. Anjali, I'll turn over to you to run through the delivery and frequency of that statement.
Yeah, thanks, Suzanne. So in terms of delivery, so for new workers, the government is proposing the statement will be provided alongside the Section 1 statement or employment particulars. But for existing workers, the government is proposing employers will need to deliver it annually, either indirectly, so via a notice board or any internal intranet, or directly, so via an email or a letter. So, Suzanne, you're now going to take us through the practical implications.
Yeah, of course. I think it's probably fairly self-evident. A huge amount needs to be done here. So when the reform is introduced, employers will need to update their employment contract templates to include this new statement for workers, depending on what the wording is going to be required when we find out from the consultations and secondary regulation. So it's a relatively simple administrative step, but one that could have, I think, a huge impact on worker awareness and potentially engagement with unions. And then secondly, employers should be just turning their minds to how they're going to go about notifying their current workforce. So do you have a staff intranet where this information could be placed? I mean, there's no huge rush to do anything really now, because I think we need to see the outcome of the consultation and secondary legislation before doing this. And the effect of this change may be even stronger when we consider it alongside the second reform you and I are going to discuss today, and that's a statutory right of trade unions to request access to a workplace, which again is due to come into force later this year in October. So Anjali, let's run through this second reform.
Yes, so the new provisions allow a qualifying union to come into the workplace to meet, represent and recruit or organise workers, so regardless of whether they are already a trade union member or not, with the aim of securing recognition through what's called an access agreement. So the union cannot, however, use this new reform to organise industrial action. And currently, unions have no independent right of access. And where they can't reach a voluntary agreement with an employer, they can only operate through individual members already in the workplace.
Yes, so in most cases, you can currently prevent a union official who's not an employee from accessing your workplace. So this is quite the change.
Yes, exactly, Susanne. And according to the government consultation document, where trade union membership is low, it limits the trade union's ability to, for example, negotiate and resolve disputes, represent workers, and to facilitate collective bargaining, as we were discussing previously. So this is something that the government would like to change.
Okay, so let's try and break it down a bit more for our listeners. So what type of trade union access are we talking about here?
So this can be physical access. So, for example, visiting a workplace or through digital communication with workers.
Yeah, so that could be like, for example, setting up a Zoom meeting
Yes.
with workers. And let's just explain for those listeners who are not so familiar with the trade union legislation as it currently is, what exactly is a qualifying trade union? Because you mentioned it's only a qualifying union who will gain access to the workplace.
Yeah, it's a great question, Susanne. So essentially, it's a union that has a certificate of independence, meaning it appears on the certification officer's official list. So the certification officer is the regulator appointed by the Secretary of State to oversee trade unions and employers' associations. So the new Act sets out a framework for how a qualifying union can request access. So the government proposes that this should be made in writing by way of an email or any letter to an employer using their standard template.
Yeah, so an employer receives potentially this email or letter, and then the consultation sets out how the employer should then respond to the trade union.
Yes.
And in that response, an employer will either accept or decline the access terms submitted by the union, and that's either in its entirety or part of them. And the consultation sets out various timeframes with which all these steps need to be adhered to. If, as an employer, you agree to a request for access, you then got to notify the Central Arbitration Committee. And again, to explain this a bit further for those who are not familiar with this framework, the Central Arbitration Committee is the independent statutory UK authority that adjudicates disputes regarding trade union recognition and collective bargaining. And again, all of this process is likely to be carried out on a standard form.
Yeah, and Susanne, some employers might be wondering what will happen if they fail to respond to an access request.
So if an employer fails to respond to the access request, or the union and the employer are unable to agree terms on which those union officials can have access to the workplace, the union has a sort of next step they can do, and that's applying to this Central Arbitration Committee I've just mentioned. And it's that committee who will then make a decision on the application regarding access. And again, there are set time periods when this has to all take place. And this Central Arbitration Committee, as the regulator, will determine whether union officials get access to your workplace or not, and the terms of the access. And as part of that, it will set out what assistance you as the employer must provide to the union. I mean, there are principles that have to be followed, which are set out in the Act, that will guide this central arbitration committee as to whether access should take place and its terms. I think it's also worth flagging there are financial penalties for employers for refusing access or not complying with this sort of statutory process. I think really the takeaway from what we've said so far is the direction of travel with these new reforms is that union access is really going to need to be facilitated by an employer if they're approached.
But Susanne, it's quite understandable that it might feel a bit daunting for some employers who aren't unionised.
Yeah, I totally agree. I mean, there's lots of detail for employers to wrap their heads around, particularly if they have limited experience of the trade union legislation. We are awaiting much of the detail in secondary legislation, so I don't think we need to panic yet. And I think it's also worth putting this new reform into practical context, particularly for smaller to medium-sized employers. So yes, if you have no union now, you may have to negotiate terms of access if a union seeks entry. And in some cases, if you don't, a regulator could set those terms for you. So for many small to medium employers, I think meaningful trade union access is probably unlikely in practice, unless your workplace has like a high profile dispute or has continued health and safety issues, or the business operates in a traditionally unionised sector. Personally, I think the change is going to be more likely felt by large employers or those in typically unionised sectors like manufacturing, retail or hospitality, or where the workforce is more receptive to unionisation. In the consultation itself, the government does address this concern about the impact this right may have on smaller employers who may find facilitating trade union access really difficult. So the government is considering, in the consultation we've touched upon, whether there should be an exemption from this new right for employers of a certain size. And currently in that consultation document, it suggested that there should be an exemption for employers with fewer than 21 workers from this new right of access. And in terms of defining that size, an employer will be defined by its total size. So that would include associated employers. And to alleviate this worry a little bit more, I think all of this reform that we've talked about, this access reform, is really going to depend on whether trade unions have sufficient officials to capitalise on this new reform and to get access into the workplace. So despite everything we've talked about, I do think employers need to keep it on their radar, particularly as the new provisions are intended to take effect in October. And for organisations with limited or no experience of the trade union landscape, I think it's probably sensible now to try and arrange training for their HR teams on what these changes actually mean in practice and what they should be preparing to do if a union does make an approach.
Exactly. And although we're waiting for secondary legislation to clarify exactly how this new right of access will work day to day, employers might want to be thinking about whether a trade union access policy is needed and how access would be managed in their practice.
Yeah.
So safeguarding, confidentiality and site security are all likely to be quite central considerations for this.
And alongside maybe producing that trade union access policy, I think sort of more minor, but amendments will need to be made to visitor policies if you have them, and your IT and communications policies, particularly because of this ability to have digital access. So we've done a whistle-stop tour of the right of access. Let's try and bring in a few other reforms if we can fit them in. We're just touching upon them. So, I mean, it depends how you calculate it, but the Act introduces around another 10 trade union-related changes, some of which we've already said took place immediately when the bill received royal assent. Obviously, in this short podcast, we're not going to be able to cover all of them. But Angie, let's just touch briefly on a few other key areas.
Yes, of course. So another big change is the simplification of the statutory trade union recognition process. So this is due to come into force in April 2026, so not long now, but it's a fairly complex area. So I'll try to summarise them in bite-sized terms if I can. So current legal thresholds require minimum levels of union membership and workforce support for there to be a recognised trade union via this statutory route. But upcoming changes in the Act will lower or remove these tests and simplify ballot rules and making it easier for unions to secure this recognition.
Yes, so it's, as you've said, it's going to make it easier for unions to gain collective bargaining rights in your workforce if you're currently non-unionised. And there's also, alongside this, enhanced protections, or there will be enhanced protections against detriment for individuals taking official or protected industrial action. And you and I actually did a few weeks ago a short podcast on the Fair Work Agency, which is going to be this new regulator enforcing labour rights such as holiday pay and sick pay. And it's also worth flagging that unions may also engage with this regulator. So it's sort of like a double whammy. So to just sort of finish up this section, I mean, the Act clearly significantly expands the powers and protections available to trade unions and their representatives. But overlaying this is whether unions will have the capacity and resources to fully take advantage of these new rights. That's really still open to question.
Right, Susanne, there is a lot coming, isn't there?
There is a lot. And so, as we've done before, it's probably worth just stepping back and just looking at the bigger picture. So for your larger unionised clients or employers, they're going to likely have a reasonable grasp of the employee relations landscape. So I suspect the reforms are unlikely to be a massive organisational step change. And those larger employers with a fragile union relationship, I think these changes will enhance union power at the bargaining table, particularly where there's changes to voting thresholds and stricter timelines and greater protections to workers striking. I mean, I know we've not covered those in detail. But with larger employers, I do think they need to think about how they're going to be impacted by these changes and prepare for an approach if they're not unionised. Now, for non-unionised clients and perhaps smaller clients, as we've mentioned, I think it's going to be a lot harder to get their heads around these reforms, particularly if they have small HR teams. They may not have established employee relations expertise or an understanding of collective bargaining. And I think it might be tempting to possibly stick your head in the sand about these reforms or just underestimate them. And you might end up finding yourself in a difficult position, particularly if a well-resourced and sophisticated union tries to establish a presence in your organisation, especially where unionisation rates are already high. So alongside thinking about how to engage constructively with any union approach within those required timeframes we've touched upon, and bearing in mind that the process may ultimately be set by a regulator if you cannot agree terms, running parallel to that, you might want to think about how to reduce the appeal of unionisation in the first place, if you're so inclined as an employer. So I think that could include addressing existing areas of dissatisfaction within your workforce and strengthening internal engagement mechanisms now. And so what do I mean by that? I mean by looking as to whether you have employee forums or listening groups or wider engagement programs with your employees to help build trust and discussion and to reduce the incentive for workers to look externally for representation via a union.
Yes, agreed, Susanne. And employers also need to keep in mind that existing legislation prevents them from taking steps to disincentivise or undermine legitimate trade union activity. So with that in view, employers might instead see this as a constructive opportunity to first reflect on how they engage with their workforce and strengthen the ways they listen, consult and involve people in their workplace decisions. And second, if a union does make an approach to handle that interaction professionally, transparently, and in a way that supports a positive working relationships.
Yeah, exactly.
So we've covered a lot today, and we both know it's impossible to do justice to every aspect of trade union reforms in a single short podcast. So as we've flagged, we've not been able to cover every reform. So if you're interested in digging deeper into the various trade union consultation documents published so far, they are a great starting point. They offer more detail and a clear sense of the direction the government are taking with this. But we can say with confidence is that the Employment Rights Act 2025 marks one of the most significant shifts in industrial relations law in over a decade. And here at Bellevue Law, we'll be watching the secondary legislation closely as it emerges. Thank you for listening, and we'll see you next time.